An indictment is not a conviction. An indictment is just a charging document charging somebody with a federal offense. So in Donald Trump's case, the grand jury, which consists of 16 to 23 people, 16 people need to be present throughout the presentation of evidence. So the Department of Justice, the prosecutors in the case, put on the evidence, and there is no defense attorney present. It is a secret proceeding, and hearsay is admissible, and they put on their evidence, and the grand jury, at least 12 of the 16 members, must find that the defendant probably committed this offense. So it is a very low standard of proof. It is nothing like the beyond a reasonable doubt standard, which is required to convict somebody of a crime. This is the grand jury. This is the starting point. This is how a federal criminal case begins. So once the indictment is returned, it is a document that lists the different charges, then the criminal case starts. So the next step, or actually the first step, is the arraignment. And what happens at the arraignment is the defendant shows up in court with their attorneys and enters a plea of not guilty. The defendant is advised of their constitutional rights. The defendant is usually assigned a district court judge for all future proceedings, and then bail is discussed. So in federal court, the judge decides if the defendant is either a flight risk or a danger to the community, or both. They can detain that person, meaning keep them in custody throughout their case. It is usually more likely in a white-collar case that the defendant is released on either a signature bond or what we call a property bond, where somebody deeds property or cash over to the court during the case. And then if the defendant shows up for all of their court proceedings, they get the money back or the property is released. In this case, it is very likely that Donald Trump will be released on his own recognizance. And then he will be able to come and go from court throughout. Now, in any other case, it is possible that the judge can impose conditions of release. The judge can impose travel restrictions. The judge can make the defendant release their passport over to pretrial services or probation to hold throughout the case. They can also put an ankle monitor on the person to make sure that they're not a flight risk. So certain restrictions are usually put in place during the arraignment for the defendant. Again, it'll be interesting to see what the conditions of release are in Donald Trump's case. My guess is that there won't be any or many. So this begins the process. The next step is the government will give the attorneys the discovery or whatever it is that they have to support these allegations. And again, this will be potentially the classified documents, but these documents have to be redacted, meaning any sensitive, classified, or secret information has to be blacked out of the document. Therefore, it is unlikely that these documents will be released, and probably the attorneys will have to go to the Department of Justice, the prosecutor's offices, to view the documents in the presence of somebody from the Department of Justice. Since the whole issue is we don't want anybody seeing these classified documents, they never should have left the White House in the first place. So that makes it a little more logistically difficult for the attorneys in this particular case. The 37-count indictment means that Donald Trump was charged with 37 different acts. One of those acts relate to 31 different documents. So this is just a sampling, because as we know, or as we have seen in the pictures, there were boxes and boxes and boxes of documents. So there were far more than 31 documents. It is possible only 31 of them were classified or secret. But the point is that the government does not have to charge every single piece of paper that was taken illegally. They only have to prove a handful of them. Like in a fraud case, the U.S. Attorney's Office doesn't have to prove every single time a defendant lied in a fraud case. They can list a handful of those occasions, or in a money laundering case, maybe a handful of the transactions, not every single one of them. They don't have to present the grand jury with all of the person's bank statements and every single payment that they made using unlawfully gained funds. So it is essentially a sampling. Now, conspiracy, what is this conspiracy charge? Conspiracy is an agreement between one or more persons to commit a criminal act, knowing of the intent of the crime, and not necessarily verbally saying, yes, Mr. President, I will do this for you, but by way of his actions, it is obvious that this person knew what was going on, and they only have to have engaged in one step in furtherance of this crime. So moving or hiding documents would be sufficient to be charged with conspiracy. And obstruction of justice is simply impeding the federal government's ability to engage in their investigation. So it is very easy for somebody to commit obstruction of justice. Also, the false statements. Anytime somebody lies to a federal agent or prosecutor, that is a crime. So he is charged with false statements by saying that he had turned over all of the documents when he hadn't. It's very simple. So the allegations in this case and the facts of this case are very black and white. I do not see how a jury votes not guilty on any of the counts in this case, except perhaps for the co-defendant. But this is very black and white. Did Donald Trump take documents that he should not have taken? Yes. Did he attempt to obstruct justice, or did he obstruct justice? Yes. And did he make false statements? Yes. So it's very interesting. It will be very, very interesting to see how all of this plays out. And I'm sure we'll be hearing all about it probably every single day until this thing is over.